दोस्तों, मैं रोहित कुमार एबनीशो की ओर से आपका स्वागत करता हूं।
Today, I am starting a new topic, that is sources of law. While talking about the sources of law, there are three sources of law that we'll be discussing here. First, custom, then legislation, and third, judicial precedent. So, talking about custom is taught in the family law also and here in the jurisprudence course also, but it is not a part of our syllabus. So, I am not going to discuss that with you here. Suffice it to say that custom is a very important source of law. And when the usage of the people, the traditions of the people culminate into practice, and with a long duration of time, those usages and practice become custom. And custom has been recognized by one of the important sources of law, by historical school of jurisprudence, mainly Carl von Savigny and also Henry Maine. But Carl von Savigny has made one exaggeration by saying that custom is the only source of law, which is not true, of course, all of us know that. But fact remains that one of the important sources of law, and it still remains to be the source of law even in the era of legislation or codification of law. I will not discuss custom more than this because it is not a part of our syllabus. Question will not be asked on custom in your examination. I am going to skip that. So two sources I'll be discussing: judicial precedent and legislation. And after that, I'll be discussing with you interpretation of statutes. That is also a part of your syllabus. So I'll start today with judicial precedent. Friends, every developed legal system, and I'm talking about developed legal system such as USA, England, India is also a developed legal system, and other continental countries as well, like Spain, France, Portugal, Germany, Greece, all these are developed legal systems. So every developed legal system possesses a judicial organ known as judiciary. We know it as judiciary. The main function of the judicial organ of the state or of the legal system is to adjudicate the rights and obligations of the citizens. जुडिशरी का मेन काम क्या है? लोगों के राइट्स और ड्यूटीज को अगर उसके बीच कोई डिस्प्यूट होता है तो उसको एडजुडिकेट करे. In the beginning, in the ancient societies, in this adjudication, the courts are guided by customs and their own sense of justice. जो societies हैं, उनके पास legislation नहीं होता है beginning में, you know that. और जब legislation नहीं होता है तो judges को कौन सी चीज गाइड करती है? Judges are guided by customs. And when there is no custom on a particular point, then their own sense of justice. What is just and what is unjust? What is good? What is bad? What is moral? What is immoral? They're guided by that sense of justice. But with the time, society progresses. And with the progress of the society, legislation becomes the main source of law. You know that. That happens everywhere in all the legal systems. So with the passage of time, legislation becomes all important source of law, and the judges decide cases according to the enacted law, according to the legislation. Even at this stage, the judges perform some very creative function. आपके पास इनैक्टेड लॉ आ जाए, आपके पास लेजिस्लेशन आ जाए, क्या इसका ये मतलब है कि जजेस का रोल वहां पे खत्म हो गया और लॉ इनैक्टेड लॉ के तहत तो वो आपको जजमेंट देने लगेंगे? ऐसा तो नहीं होता, किसी भी सोसाइटी में नहीं होता. जुडिशरी, इवन इन दैट स्टेज वेयर दे हैव लेजिस्लेशन इन देयर हैंड्स, play a very creative role. They perform some creative function in judiciary. There are three types of cases. In the cases of first impression, they decide cases on their own sense of justice. क्योंकि वहां पे लॉ है ही नहीं, लॉ साइलेंट होता है. साइलेंट क्या होता ही नहीं है, because these are cases of first impression, जहाँ पे आपके पास कानून बिल्कुल भी नहीं है. At that place, judges decide that particular case on their own sense of justice. In the matters of interpretation, suppose they have law in their hands, they have a legislation which is full and complete, but that requires interpretation. Every law is not clear. Every law is not specific. Every law is not unambiguous. Sometimes ambiguity arises in law. That requires interpretation. So even if you have a law in hands, that requires interpretation. And there also, judges play a very important role, very creative role. Sometimes, apart from the ambiguity, there are certain gaps in the law. There are certain lacunas in the law made by the legislature. In filling up those gaps and lacunas, judges also play some very creative function. And here also judges depend on their own sense of justice to a certain extent. They depend on their own sense of what is right and what is wrong. In doing that, they adapt the law to the changing conditions of the society. Because society is never static. in a developed legal system. It keeps changing. And when judges want to adapt law to the changed condition of the society, and when they want to fill up those gaps left by the legislatures, they depend on their own sense of what is right and what is wrong. The decisions on these points where there is ambiguity, there is no law, or there are gaps, decisions on these points become authority, or it becomes guide for the subsequent cases of a similar nature. And this is known as judicial precedent. When a case decided by a judge becomes guide for a subsequent cases of the similar nature, that is nothing but a precedent. Now we'll talk about a couple of methods of this judicial precedent. There are two methods, no doubt. Inductive method and deductive method. I'm repeating it. Inductive method and deductive method. Friends, there are those legal systems where much of the development of law has taken place through this creative role of the judges. You know that the English legal system is the best example of that. There, the entire legal system was developed by the judges, and that is why we know that it is a common law. India also, to the good extent for a very long time, was dependent upon common law. In fact, entire law of torts has been developed by the judges. So our legal system is a part of a common law legal system which is still followed in England and some other European countries and America as well. In those legal system, a great reliance is placed upon the decisions of the judges. आज भी जजेस के डिसीजंस पे बहुत ज्यादा रिलायंस प्लेस किया जाता है ऐसे लीगल सिस्टम्स में. हालांकि टुडे इंग्लिश लीगल सिस्टम इज डिपेंडेंट मोस्टली अपॉन the statute, and that too they rely mostly on a literal interpretation of the statute that I will be discussing with you in the future lectures. But suffice it to say that English legal system has made of common law, has made by the judges. What happens here? In deciding a case, the judges look into the previously decided cases of the similar nature by their own court or by superior court. So what judges do? They see whether they have decided the case previously, or do they have a case of a similar nature judgment delivered by any superior court. Say for example, any high court will look into the decision of House of Lords. Now they don't have a House of Lords, they also have a Supreme Court in England. So this is how it is. This is how it works. From particular cases, they deduce a general rules and apply them on the cases before them and decide them accordingly. So क्या करते हैं कि वो cases को deduce करते हैं, I mean जनरल रूल को डिड्यूस करते हैं प्रीवियसली डिसाइडेड केसेस से और उसको फ्यूचर केस पे जस्ट अप्लाई करते हैं अकॉर्डिंग. दिस इज नोन एज इंडक्टिव मेथड, क्योंकि वो प्रीवियसली डिसाइडेड केस के रूल को फ्यूचर केस में इंडक्ट करते हैं. वो डिड्यूस करते हैं इसलिए उसको डिडक्टिव नहीं कहते हैं, लेकिन वो फ्यूचर केस में इंडक्ट करते हैं इसलिए उसको इंडक्टिव. However, there are certain legal systems where most of the law is embodied in legislation. Continental countries, मैंने इनका नाम अभी आपको बताया था, इटली, पोर्चुगल, स्पेन, फ्रांस, जर्मनी, ग्रीस. These are the countries where most of the law is embodied in a statutes today. Such legal systems may be called civil law systems. They are civil law systems. They are not common law systems. उनका पूरा legal system ही different है, civil law system. When I'll discuss with you major legal systems in the world, there I'll discuss both the legal systems in detail, civil law system as well as common law system. Civil law system is also known as Romano-Germanic legal system. So this civil law system functions in continental countries. The law in most part in this country is codified. यहाँ पे पूरा law आज की डेट में codified है. The judges decide cases according to the law laid down in the code, in the legislation. And they are not to look for the previously decided cases of the similar nature. वहाँ पे लोग precedent की तरफ ज्यादा ध्यान नहीं देते. इसका ये मतलब नहीं है कि बिल्कुल भी ध्यान नहीं देते, लेकिन बहुत ज्यादा ध्यान वो previously decided cases पे देते नहीं है, क्योंकि उनके पास well defined codes हैं. वो सिर्फ अपनी law codes की तरफ देखेंगे, previous decisions की ओर उनका ज्यादा ध्यान होता नहीं है. And this is known as the deductive method. So you know now what is inductive method and deductive method. Under this method, general legal rules are applied to particular cases. जनरल लीगल रूल्स यहाँ पे कौन से? वही जो ऑलरेडी स्टैट्यूट में है. एंड दोज रूल्स आर अप्लाइड टू पर्टिकुलर केसेस. फ्रेंड्स, नोट डाउन दैट दीज टू मेथड्स, इंडक्टिव मेथड्स एंड डिडक्टिव मेथड्स, दे आर नॉट अपोज्ड टू ईच अदर. Practically, they appear to be functioning together. The distinction which we are talking about is theoretical in nature. The difference between these two methods, inductive method and deductive method is only that of degree. So here I give a pause for maybe किसी को कोई क्वेश्चन तो नहीं पूछना? अजय जी, कोई क्वेश्चन तो नहीं है आपका?
नहीं सर,
हाँ चलिए फिर मैं स्टार्ट कर रहा हूँ.
प्लीज.
Friends, in almost all the legal systems, the judges take guidance from the previous decisions on a particular point and they rely upon those decisions. But the authority of such decisions is not the same in all the legal systems. कहीं पे कम है, कहीं पे ज्यादा है. जैसे continental countries में मैंने आपको बताया था वहाँ पे कम है, और common law countries में judicial decisions पे ज्यादा reliance. In most of the countries, उसमें इंडिया भी है, there lawyer acquire their knowledge of law more from the decisions of the higher courts like High Court and Supreme Court than from anything else. In fact, some jurists go on to say that best way of understanding law is to read cases. It shows how it is important for the judges to take guidance from the previously decided cases on the point. Such decisions are published, आपको मालूम है, कई सारे जर्नल्स में पब्लिश होते हैं, जिसमें AIR है, ऑल इंडिया रिपोर्टर, SCC है, अभी तो SCC ऑनलाइन है, पहले SCC था सिर्फ, SCC ऑनलाइन, फिर मनुपात्रा में मिल जाएंगे आपको, लीगल सर्विसेज इंडिया में मिल जाएंगे, लाइव लॉ में मिल जाएंगे. There are so many websites today. So these decisions are published. They are compiled in reports. These reports are considered to be a very valuable part of legal literature. These decisions are very useful in deciding the subsequent cases of similar nature. Judges के लिए कितने important होते हैं ये cases कि judges को कोई भी subsequent case उनके सामने similar point पे आया तो उसको decide करने में वो guide करते हैं. These cases are called judicial precedents. Previously decided cases हैं तो उन्हें judicial precedent कहा जाएगा because they set a precedent for the future cases. They are called precedent also. Sometimes they are called judicial precedent, sometimes they are called precedents. As such, it is a very important source of law. तो क्योंकि मैंने आपको बताया कि ये बहुत important source of law है, जैसा कस्टम है, लेजिस्लेशन है, वैसा जुडिशियल प्रेसिडेंट इज ऑल्सो अ वेरी वेरी इंपॉर्टेंट सोर्स ऑफ लॉ. तो इसलिए इसकी डेफिनेशंस देखना भी बहुत बहुत इंपॉर्टेंट है. तो सबसे पहली डेफिनेशन जो मैं आपको दे रहा हूं, दैट इज गिवन इन द ऑक्सफोर्ड डिक्शनरी. इन ऑक्सफोर्ड डिक्शनरी, प्रेसिडेंट हैज बीन डिफाइंड एज अ प्रीवियस इंस्टेंस और केस which is or may be taken as an example of rule for subsequent cases or by which some similar act or circumstances may be supported or justified. This is an Oxford Law Dictionary definition of judicial precedent. Number of jurists have also given their own definitions of precedent, which we will not go into because lecture will be prolonged by doing that. But in general use, what do we mean by the word precedent? In general use, precedent means some set pattern guiding the future conduct. That is precedent. Then it is also important to see what is the meaning of the term precedent in a judicial sense, or what is the meaning of the term precedent in a judicial field. In judicial field, it means the guidance or authority of past decisions for future cases. May I repeat this? Guidance or authority of past decisions for future cases. Friends, only these type of decisions which lay down some new rule or some new principle for the future cases, they are known as judicial precedents. It is the attribution of authority that makes a judicial decision a judicial precedent. It is attribution of authority. किस केस की अथॉरिटी कितनी है, ये अगर आप जान जाएंगे तो आपको पता चलेगा कि कौन सा केस सिर्फ प्रेसिडेंट है और कौन सा जुडिशियल प्रेसिडेंट. द एप्लीकेशन ऑफ सच जुडिशियल प्रेसिडेंट इज गवर्न्ड बाय डिफरेंट प्रिंसिपल्स इन डिफरेंट लीगल सिस्टम्स. These principles are called the doctrine of precedent. जो प्रिंसिपल आपको प्रीवियस केस में मिल जाता है फ्यूचर केस के ऊपर अप्लाई करने के लिए, उसको डॉक्ट्रिन ऑफ जुडिशियल प्रेसिडेंट कहते हैं. इट मीन्स टू थिंग्स. फर्स्ट, दैट सच प्रेसिडेंट्स आर रिपोर्टेड, दे मे बी साइटेड एंड दे मे प्रोबेबली बी फॉलोड बाय कोर्ट्स. इसको दोबारा सुनिए. इन द फर्स्ट प्लेस, सच डिसीजंस, सच प्रेसिडेंट्स आर रिपोर्टेड. रिपोर्ट तो होते हैं, बट दे मे बी साइटेड. जरूरी नहीं है कि उन्हें साइट किया ही जाएगा. दे मे बी साइटेड, they may probably be followed by courts. ये तो first sense में हुआ. And in the second sense, the precedent under certain circumstances must be followed. Report तो होते हैं, but they must be followed in certain circumstances. This doctrine of precedent in its first sense prevails in the continental countries. sense. It also prevailed in its first sense in England before 19th century. क्या होता था कि डिसीजंस रिपोर्ट तो होते हैं बट उनका फॉलो होना जरूरी नहीं है. ये कॉन्टिनेंटल यूरोप में होता है. इंग्लैंड में भी होता था पहले कि प्रेसिडेंट का फॉलो होना जरूरी नहीं था क्योंकि डॉक्ट्रिन ऑफ प्रेसिडेंट तब तक आई नहीं थी वहां पे. डॉक्ट्रिन ऑफ प्रेसिडेंट तो अब आया है ना 19th सेंचुरी के बाद. उसको डॉक्ट्रिन ऑफ प्रेसिडेंट को एस्टैब्लिश होने के लिए मैं बताऊं आपको 400-500 साल लग गए. ये एक बड़ा पीरियड होता है. उस हिस्ट्री को भी मैं आपसे डिस्कस करूंगा. नो डाउट आई हैव टू डिस्कस दैट. बट सफाइस इट टू से दैट इन द फर्स्ट सेंस व्हेन केसेस गेट्स रिपोर्टेड बट दे विल बी फॉलोड, देयर इज नो गारंटी ऑफ दैट. But application of the doctrine in the second sense is a specific feature of the English legal system. That means they must be followed. वो follow होते ही होते हैं. Precedent follow होते हैं. इंग्लैंड में आज भी follow होते हैं. Yes, they now depend on literal interpretation of the statute. That is true. But if they have case, they do follow that case. With some modifications, it is followed in many countries, including our own country, that is in modern legal systems plays a very important role. Among the modern legal systems, the Anglo-American law is judge-made law, common law. It emerges from the common law, that is judge-made law. Everybody knows that. It developed mainly through judicial decisions. Common law has been mainly developed by the judges. Most of the branches of law, such as torts, have been created exclusively by the judges. In fact, the constitutional law of England, especially the freedom of the citizens, they've been developed through the judicial decisions. England में तो constitution written law है ही नहीं. Constitutional law England में documented है ही नहीं. Largest डॉक्यूमेंट कॉन्स्टिट्यूशन का अगर लार्जेस्ट डॉक्यूमेंट ढूंढोगे तो वो हमारे भारत का है. एवरीवेयर द कॉन्स्टिट्यूशनल प्रिंसिपल्स हैव बीन रिटन डाउन ऑन अ डॉक्यूमेंट, बट इन इंग्लैंड इट इज नॉट सो. सो इंग्लिश कॉन्स्टिट्यूशन इटसेल्फ, मेनी jurists say, including Dicey, that it is a judge-made constitution. At least freedom of the people have been a judge-made thing there in England, and that is why it is important to see what is the opinion of some jurists regarding judicial precedent. First, I am taking the opinion of Gray. Gray says that a precedent covers everything said or done which furnishes a rule for subsequent practice, and this, he says, is known as a nature and the sources of law. Second view is of the jurist known as Kitten, K-E-E-T-O-N, Kitten. He says a judicial precedent is judicial to which authority has in some measures been attached, and this he says is an elementary principles of jurisprudence. Friends, researchers made in recent years, especially the study of papyri, have discovered that in Egypt was a well-known civilization, and in the past century, a lot of things regarding Egyptian civilization have been found out. So in Egypt, in the period which corresponded to the classical era of Roman Empire, the use of precedent was made in the court of law in daily practice. वहां पे लॉ इतना डेवलप था इजिप्ट में ड्यूरिंग द क्लासिकल एरा ऑफ रोमन jurisprudence कि जुडिशियल प्रेसिडेंट का यूज डेली बेसिस पे होता था. इट वाज इन सम रिस्पेक्ट सिमिलर टू द प्रैक्टिस ऑफ आवर ओन कोर्ट्स इन आवर ओन टाइम. इट इज आल्सो सेड दैट जस्टिनियंस डिक्लेरेशंस इटसेल्फ इज इंडिकेटिव ऑफ द टेंडेंसी ऑफ द जजेस टू फॉलो जुडिशियल प्रेसिडेंट्स, व्हिच मे और मे नॉट बी ट्रू. We don't know that, and we will not even go into that. Here I am taking 1 or 2 minutes pause so that if you have any question you can ask. There is a great importance which is attached to the judicial precedents, and it is a distinguishing feature of the English legal system. The edifice of the common law is made up of the judicial decisions. In no legal system of the world so much authority is vested with the precedents as it is vested in England. Though the present English doctrine of judicial precedents came into being in 19th century, its history goes many centuries back. मैंने आपको बताया था कि वो हिस्ट्री मैं आपसे डिस्कस करूंगा. जुडिशियल प्रेसिडेंट की डॉक्ट्रिन जो है वो 19th सेंचुरी में वेल स्टैब्लिश जरूर हुई है, बट इट टुक 400-500 years to develop that practice. The organization of the judicial system, the power and the authority of the judges, their legal thoughts, and the publication of the law reports all helped in the growth of the doctrine of judicial precedent in England. Although jurists have tried to prove the existence of law reports in England at the time of King William the Conqueror, it is only a conjecture. ये सही नहीं है. King William's Conqueror जो थे 13वीं सदी में, उनके समय में law reports नहीं होती थी इंग्लैंड में. Everybody knows that. But some jurists try to prove that with some evidences. वो चलता रहता है. Jurists अपनी कोशिश, historians, jurists अपनी कोशिशें करते रहते हैं कुछ प्रूव करने की, लेकिन वैसा होता नहीं है. It is from the time of Bracton Bracton onwards. Bracton की जो report थी, they played a very important role in establishing a judicial precedent. In the time of Bracton onwards, that the decided cases started occupying an important place in the legal literature. Bracton's की जो report, वहां से cases का legal literature में आना एक बहुत बड़ी. In Bracton's own treatise, there are about 500 references to decided cases. और ये बहुत बड़ी बात. उस जमाने में 500 references decided cases के मिल जाना, एक जगह पे मिल जाना, that was a big thing. The practice of citation of cases also seems to have started at this time. मैं इसका एक एग्जांपल दे. आपका एक केस है एशबी वर्सेस वाइट. इंजुरी असाइन डैमनो का केस है, लॉ ऑफ टॉर्ट्स का. काफी पुरानी साइटेशन है, इफ यू रिमेंबर दैट, एशबी वर्सेस वाइट. सो उस समय से आपको साइटेशंस मिलने की शुरुआत हो जाती. नाउ फ्रॉम द 14th century, the publication of yearbooks started for the decided cases, and that went on assuming authority. ईयरबुक्स जो आज की लॉ रिपोर्ट्स है, उस समय ईयरबुक्स होती थी, आज भी है ईयरबुक्स. तो वो 14th सेंचुरी से उनका आना धीरे धीरे शुरू हो जाता है और उनको इंपॉर्टेंस मिलना भी शुरू हो जाता है, क्योंकि जजेस के लिए भी वो इजी होता है. इन द फॉलोइंग सेंचुरीज, दैट इज 15th, 16th and 17th century, रेगुलर, एक्यूरेट एंड वेल ऑर्गेनाइज्ड रिपोर्टिंग ऑफ केसेस डेवलप. द टर्म प्रेसिडेंट फॉर प्रेसिडेंट became popular at this time. The bench and the bar, that is judges and the lawyers. Bench means judges and the bar means lawyers. The bench and the bar both consciously started attributing authority to decided cases. Coke's reports. Coke was a judge at that time, somebody who talked a lot about administrative discretion, and perhaps he gave one definition of administrative discretion. It is not relevant to talk about it here, but suffice it to say that the Coke was very renowned judge and occupies a great respect in English legal literature. So Coke's reports are a very important landmark in the history of reporting and in the development of the doctrine of judicial precedent in England. Some other distinguishing persons from the bench, that from the judiciary, who contributed to the development of the doctrine of judicial precedents were Vaughan, Vaughan, Vaughan and Lord Mansfield. These judges laid down a number of rules regarding the doctrine of judicial precedent. Now we come to the 18th and 19th century. In 18th and 19th century, the judicial system was reorganized in England and the hierarchy of courts was clearly settled there. Reporting of cases was regularized and it improved considerably in many respects. It was in the later half of the 19th century, that means after 1850, that the present doctrine of judicial precedent was established in England. Now let me discuss some general principles of the doctrine of judicial precedent there. The first general rule of the doctrine of precedent is that each court is absolutely bound by the decision of the court above it. That means High Court is bound by the decision of House of Lords and subordinate courts are bound by the decisions of all the higher tribunals. The second rule is that to a certain extent, higher courts are bound by their own decisions. You cannot bind the higher courts for their own decisions, right? Because it will make a bad precedent. Why? Because they will not be able to change their own decisions even if that is required. So you cannot bind them completely and absolutely for their own decisions. And this is a special feature of the English doctrine of judicial precedent. Let me also tell you, our Supreme Court is also not absolutely bound by their own decisions. So here I give a pause because I have completed with the history of English legal system about the doctrine of judicial precedent.
दोस्तों, इस तरह के वीडियो को बनाने में काफी समय, मेहनत और रिसोर्सेस लगता है. आप अपना वैल्यूएबल फीडबैक जरूर शेयर करें ताकि एबनिशियो टीम को प्रोत्साहन मिले तथा आपके द्वारा दिए गए फीडबैक पर काम करके और इन्फॉर्मेटिव वीडियोस आप तक लाया जा सके. प्लीज लाइक द वीडियो, सब्सक्राइब द चैनल एंड शेयर द वीडियो with needy one.
Now I'll talk about India. And in India, the legal system was not very well developed system before late 19th and 20th century. So here there was nothing like a judicial precedent in ancient and medieval time. During the British rule, especially after establishment of British rule in the country, what they did for some time, that English people administered justice in India according to the personal laws of the parties with the help of Pandits and Maulvis. जो 18th सेंचुरी का जो पीरियड था, राइट फ्रॉम द प्लासी वॉर, बक्सर है ना, ये जो प्रीवियस वॉर्स थे, तो उस समय सिचुएशन डिफरेंट थी. ब्रिटिश एडमिनिस्ट्रेटर्स को यहाँ के कल्चर के बारे में कुछ भी नहीं पता था. So they just did not want to do much with it, and they administered justice according to the personal laws of the parties. And who helped them? Pandits and Maulvis. Now, Regulating Act came in 1773. By the Regulating Act, Supreme Courts were established first at Calcutta, which was known as Fort William also, and then at Bombay and Madras. So these were the presidency towns, Calcutta, Bombay and Madras. After some times, the high courts were established in provinces, other provinces, like you had Agra High Court, you had Patiala High Court, you had Lahore High Court. These were the older high court, Allahabad High Court. So these were the high court. But there was no relationship between the Supreme Courts and the high courts. दोनों कोर्ट्स अलग थे. ऐसा नहीं था कि हाई कोर्ट से अपील सीधे सुप्रीम कोर्ट जाती थी, ऐसा नहीं था. हाई कोर्ट से अपील कहाँ जाती थी? इंग्लैंड में जाती थी, प्रिवी काउंसिल. और सुप्रीम कोर्ट में से भी अपील कहाँ जाती थी? प्रिवी काउंसिल में. Why? Because they were independent of each other. High courts and Supreme Court were independent of each other. They administered two different set of law. वो जो law administer करते थे वो same नहीं था, different था, एक दूसरे से different था. When many of the branches of the law were codified, like you had CPC, which was codified in 1859, I guess. IPC was codified in 1860. Indian Contract Act 1872. Indian Evidence Act 1872. Transfer of Property Act 1882. So these laws were codified. Now, both kinds of courts started administering the same law. When the Judicial Committee of the Privy Council became the final appellate tribunal for India, a new chapter was added in the Indian legal system or in the Indian legal history. एक नया chapter add हुआ क्योंकि यहाँ से डायरेक्टली अपील जाने लग गई प्रिवी काउंसिल में और सुप्रीम कोर्ट और हाई कोर्ट दोनों सेम लॉ एडमिनिस्टर करने लगे. नाउ अ क्लियर हायरार्की ऑफ द कोर्ट्स वाज एस्टैब्लिश्ड in India also. There were presidency courts in the presidency towns like Bombay, Madras and Calcutta at the lower level, and mufassil courts were there at the district level. डिस्ट्रिक्ट लेवल में जो सबसे लोएस्ट कोर्ट थे उनको मुफस्सिल कोर्ट कहते थे और प्रेसिडेंसी टाउन्स में जो लोअर लेवल पे कोर्ट्स थे उनको प्रेसिडेंसी कोर्ट्स कहते थे. एंड अबव दीज कोर्ट्स देयर वर हाई कोर्ट्स. द प्रिवी काउंसिल वाज द फाइनल appellate tribunal for Indian court. Every court was bound by the decisions of the superior court. That means presidency court was bound by the decision of the high court and privy council, and high court was bound by the decision of the privy council. And this helped in bringing uniformity and certainty in law in India, because the decisions of privy council were binding on all the courts in British India. British India में privy council के decisions binding हो गए थे सभी courts पे. And in spite of many serious lacunas, very serious drawback of such judicial system, it rendered this one valuable service to the Indian legal system, that it brought uniformity in the Indian legal system. Thus, the doctrine of judicial precedent in the modern sense of the term took its birth in India. Reporting of Indian cases also started about this time. Now, with the beginning of 20th century, many reports came into existence. Now, sumptuous citations of cases started in the courts. India में बहुत अच्छे citations केसेस के अब मिलने लगे. तो ये था उसका शुरुआती दौर, इंडियन लीगल सिस्टम का शुरुआती दौर. नाउ द मेजर पार्ट of this legal system was started in 1935, क्योंकि almost हमारा legal system जो है वो 1935 Act से, यानी कि Government of India Act 1935 से inspired है आज भी. So by the Government of India Act 1935, here Federal Court was established. तो इंडिया में Federal Court establish हुआ. Federal Court इंडिया में सबसे topmost court था, हालांकि अभी भी Final Appellate Tribunal Privy Council ही था, but High Courts भी थे. High Court के ऊपर Federal Court था और Federal कोर्ट के ऊपर प्रिवी काउंसिल था. So this was an interposition in the hierarchy of courts in India. This act provided that the decisions of the superior court will have the binding effect on the courts below. तो प्रिवी काउंसिल का डिसीजन फेडरल कोर्ट और बाकी सभी कोर्ट्स पे बाइंडिंग होता था. फेडरल कोर्ट का डिसीजन हाई कोर्ट्स और बाकी सभी सबऑर्डिनेट कोर्ट्स पे बाइंडिंग होता था और हाई कोर्ट का डिसीजन सभी प्रोविंशियल लेवल पे सभी सबऑर्डिनेट कोर्ट्स पे बाइंडिंग होता था. In this regard, Section 212 of the Government of India Act 1935 was very important because it made the provision that the law declared by federal court and by any judgment of the Privy Council shall, so far as applicable, be recognized as binding on and shall be followed by all courts in British India, and so far as respect the application and interpretation of the act or any order in council thereunder or any matter with respect to which the federal legislature has power to make law in relation to the state in any federal state. Provision is very, I'll not go in detail of that, but suffice it to say that the position after 1935 is like this, that the decision of the federal court were binding on all the courts below it. The decision of the Privy Council were binding on the federal court and the courts below that. The Privy Council was not bound by its own decision. जैसा कि सुप्रीम कोर्ट हमारा है, सुप्रीम कोर्ट is not absolutely bound by its own decision, क्योंकि सुप्रीम कोर्ट को कई बार अपना प्रेसिडेंट चेंज भी करना पड़ता है in the interest of justice. That was the same position with regard to the Privy Council. I am giving a pause here.
दोस्तों, इस तरह के वीडियो को बनाने में काफी समय, मेहनत और रिसोर्सेस लगता है। आप अपना वैल्यूएबल फीडबैक जरूर शेयर करें ताकि एबनिशियो टीम को प्रोत्साहन मिले तथा आपके द्वारा दिए गए फीडबैक पर काम करके और इन्फॉर्मेटिव वीडियोस आप तक लाया जा सके। प्लीज लाइक द वीडियो, सब्सक्राइब द चैनल एंड शेयर द वीडियो विद नीडी वन।
Once again, Indian Constitution now, which was implemented in 1950. So after independence of the country, you know that the Privy Council ceased to be the appellate tribunal for India. Privy Council खत्म हो गया in 1950 because Supreme Court had established here in India, and Federal Court was also abolished. जो इंग्लैंड ने यहाँ पे establish किया था Federal Court, that was also abolished. So by the Indian Constitution 1950, a Supreme Court has been established, which is the final appellate tribunal even today. In states, there are high courts, and in district, there are district courts. The courts of the first instance in criminal case are the Judicial Magistrates Court, and in metropolitan cities, the Court of the Metropolitan Magistrate. तो सबसे ऊपर सुप्रीम कोर्ट है, फिर स्टेट्स लेवल पे हाई कोर्ट है, डिस्ट्रिक्ट लेवल पे मैजिस्ट्रेट्स कोर्ट है क्रिमिनल केसेस में, और मेट्रोपॉलिटन सिटीज में कोर्ट ऑफ द मेट्रोपॉलिटन मैजिस्ट्रेट्स। ये हायरार्की है। इन सिविल केसेस द कोर्ट ऑफ द फर्स्ट इंस्टेंस इज द मुंसिफ्स कोर्ट, डिस्ट्रिक्ट लेवल। इसके अलावा इन मेनी स्टेट्स देयर आर थर्ड सेट ऑफ कोर्ट्स आल्सो, दे आर नोन एज द रेवेन्यू कोर्ट्स, and these courts have been established for decisions of the revenue cases. तो ये हायरार्की है। तो इस हायरार्की को बस आप अंडरस्टैंड कर लें, क्योंकि कई बार 5 मार्क्स का क्वेश्चन हायरार्की ऑफ कोर्ट से भी आता है। तो यहाँ पे जनरल प्रिंसिपल सब आप अंडरस्टैंड कर लीजिए। जनरल प्रिंसिपल्स क्या है, वो हमारा लास्ट पॉइंट है आज। यस अजय जी प्लीज।
सर ये मेरे को पूछना था, जैसे ट्रिब्यूनल्स होते हैं,
हाँ,
जैसे आपका इनकम टैक्स का एपीलेट ट्रिब्यूनल हो गया, कस्टम्स, जीएसटी, सेंट्रल एक्साइज का जो ट्रिब्यूनल हो गया, वो
ट्राइब्यूनल्स है, वो कोर्ट्स नहीं है।
मैं मान गया आपकी बात, मैं ये पूछ रहा हूँ तो ये हायरार्की में कहाँ फिट होते हैं? आर दे एट मजिस्ट्रेट लेवल, स्टेट लेवल और विच लेवल? इवन इन लाइक जैसे एनजीटी, जैसे नेशनल ग्रीन ट्रिब्यूनल है या कम्युनल एपीलेट ट्रिब्यूनल।
यस यस, आई एम कमिंग टू दैट। There are certain state tribunals, whereas there are certain central tribunals. जैसे कि कैट है, वो है सेंट्रल एडमिनिस्ट्रेटिव ट्राइब्यूनल्स। लेबर कोर्ट सेंट्रल ट्राइब्यूनल है वो, हाँ? तो कुछ तो सेंट्रल ट्राइब्यूनल है, कुछ स्टेट लेवल पे भी है ट्राइब्यूनल्स। Secondly, they are not court. They are having judicial powers though, and some tribunals are having quasi-judicial powers, like Disability Commission. Disability Commission is kind of a tribunal, but it has a quasi-judicial jurisdiction. तो ये कोर्ट्स के अलावा होते हैं ट्राइब्यूनल्स, और ट्राइब्यूनल्स हायरार्की में जो है कोर्ट्स की हायरार्की में नहीं आते हैं। ट्राइब्यूनल्स अलग से सेटअप होते हैं।
ओके, थैंक यू।
इसलिए मैंने उसको डिस्कस भी नहीं किया, बिकॉज जहां पे भी हाई कोर्ट की जुरिस्डिक्शन का सवाल आता है या सुप्रीम कोर्ट की जुरिस्डिक्शन का सवाल आता है, सुप्रीम कोर्ट्स एंड हाई कोर्ट्स डिसीजंस आर बाइंडिंग ऑन ऑल द कोर्ट्स एंड ट्राइब्यूनल्स। तो ऑल द कोर्ट्स एंड ट्राइब्यूनल्स क्यों यूज करते हैं टर्म? क्योंकि ट्राइब्यूनल्स जो है कोर्ट्स की हायरार्की में नहीं आते हैं। दैट्स व्हाई दे यूज द टर्म ऑल द कोर्ट्स एंड ट्राइब्यूनल्स।
मेरा एक डाउट इसलिए रेज हुआ था क्योंकि जैसे अगर हम मतलब टैक्स केसेस की अपील्स में जाते हैं तो डायरेक्टली फ्रॉम दी एपीलेट ट्रिब्यूनल अगर हमको ओवर एंड अबव अपील करनी होती है, देन वी गो टू द हाई कोर्ट एंड सुप्रीम कोर्ट। बट ये है कि ऑन द क्वेश्चन ऑफ फैक्ट ओनली वी कैन गो टिल द ट्रिब्यूनल्स, starting thereon from for the question of law only we can go to high court or above.
Absolutely. और ये भी मैं थोड़ा सा एक पोजीशन आपको क्लियर कर देता हूँ कि in 1985 these tribunals were established under the Judicial Tribunal Act. There is one National Tribunal Act also. लेकिन वहाँ पे एक पोजीशन अराइज हुई कि जैसे आप टैक्स ट्राइब्यूनल से वगैरह अपील करते हैं तो पहले आप सिर्फ सुप्रीम कोर्ट से करते थे, क्योंकि उस पे एक एसपी संपत कुमार का जजमेंट था। वो जजमेंट ये कहता था कि आप सीधे सुप्रीम कोर्ट में जा सकते। हाई कोर्ट की जुरिस्डिक्शन को इस एक्ट ने खत्म कर दिया था। But in 1997, there came another decision of the Supreme Court in the case of L. Chandra Kumar versus Union of India. And in that judgment, Supreme Court gave the power to the citizens to file first appeal on the question of law, mainly to the High Court also. But sometimes, apart from the question of law, court can also examine error of law which is apparent on the face of the record, mainly administrative law cases also, under its certiorari jurisdiction, under its power of writ of certiorari.
Right.
So
Right.
that is there. Earlier that jurisdiction was with the Supreme Court. Now after 1997, it has also again been given to the High Court and then to the Supreme Court. Now let us discuss the principles. The decisions of the High Court are binding on all the subordinate courts and tribunals within its jurisdiction. देखिए यहाँ पे भी term tribunal आया है, हाँ? So the decisions of High Court are binding on all the subordinate courts and tribunals within its jurisdiction. The decisions of one High Court have only a persuasive value in a court which is within the jurisdiction of another High Court. Suppose दिल्ली हाई कोर्ट का कोई जजमेंट है, आप उसके बेसिस पे कोई केस लड़ रहे हैं इलाहाबाद हाई कोर्ट के जुरिस्डिक्शन में किसी कोर्ट में, तो वहाँ उसकी क्या वैल्यू है? सिर्फ परसुएसिव वैल्यू है, वहाँ उसको बाइंडिंग इफेक्ट नहीं मिल सकता है. बट इफ सच डिसीजन इज इन कॉन्फ्लिक्ट विद एनी डिसीजन ऑफ द हाई कोर्ट विद इन हुज जुरिस्डिक्शन that court is situated, it has no value and the decision of that high court is binding on the court. Suppose आपके पास कोई दिल्ली हाई कोर्ट का डिसीजन है, उसके बेसिस पे आप इलाहाबाद हाई कोर्ट के जुरिस्डिक्शन में आर्ग्यू कर रहे हैं और आपके पास जो डिसीजन है दिल्ली हाई कोर्ट का वो कंफ्लिक्ट कर रहा है इलाहाबाद हाई कोर्ट के जजमेंट से, तो आपका दिल्ली हाई कोर्ट के जजमेंट की कोई भी वैल्यू नहीं है, राइट? वहां पे इलाहाबाद हाई कोर्ट का जजमेंट उसकी वैल्यू है, तो इलाहाबाद हाई कोर्ट का जजमेंट वहां पे बाइंडिंग रहेगा. इन केस ऑफ देयर बीइंग एनी कंफ्लिक्ट between the two decisions of co-equal benches, the decision and later in time is to be followed. दो co-equal benches के बीच अगर कंफ्लिक्ट आ जाता है तो जो डिसीजन बाद में दिया गया हो वो बाइंडिंग होगा. However, it has been observed that when judgment of the superior court are of co-equal benches and therefore of matching authority, then their weight inevitably must be considered by the rationale and logic thereof and not by the mere fortuitous circumstances of the time or date on which they were rendered. मतलब अगर superior courts के अगर judgment है co-equal benches के, तो इसके बारे में सुप्रीम कोर्ट का एक डिसीजन है, वो ये कहता है कि आपको सिर्फ टाइम और डेट के हिसाब से नहीं जाना चाहिए बल्कि उसके रैशनल के हिसाब से जाना चाहिए कि कौन से केस का रैशनल ज्यादा सही है, अगर कोई इक्वल बेंचेस के भी है तो भी. नाउ दिस इज वेरी इंपॉर्टेंट. वन बेंच ऑफ द सेम हाई कोर्ट कैन नॉट टेक अ व्यू विच इज कॉन्ट्ररी टू द डिसीजन गिवन बाय अर्लियर बेंच बाय कोऑर्डिनेट बेंच ऑफ दैट हाई कोर्ट. इट इज बाउंड बाय सच डिसीजन. अगर कोई इक्वल बेंचेस है तो एक जज सेम हाई कोर्ट के जज ने जो पहले ओपिनियन लिया है उससे उसके अगेंस्ट नहीं जा सकता. द डिसीजन ऑफ द डिवीजन बेंच इज बाइंडिंग ऑन अ सिंगल जज ऑफ द सेम हाई कोर्ट. ये तो नेचुरल है क्योंकि डिवीजन बेंच में दो जजेस होते हैं मेनली, तो डिवीजन बेंच का जजमेंट तो सिंगल जज पे बाइंडिंग होगा, ऑल्दो द डिसीजन ऑफ डिवीजन बेंच मे बी रॉन्ग. इवन इफ द डिसीजन ऑफ द डिवीजन बेंच इज रॉन्ग, इट इज बाइंडिंग ऑन द सिंगल जज. सिंगल जज कैन नॉट करेक्ट. इफ अ लर्नेड सिंगल जज हियरिंग अ मैटर is inclined to take the view that the earlier decision of the High Court, whether of a division bench or of a single judge, needs to be reconsidered, he should not embark upon that inquiry sitting as a single judge, but should refer the matter to a division bench or in an appropriate case, place the relevant papers before the Chief Justice to enable him to constitute a larger bench to examine the question. मान लीजिए सिंगल जज को डिवीजन बेंच का या किसी सिंगल जज का डिसीजन ऐसा लगता है कि रिकंसिडर करना चाहिए, तो वो खुद नहीं कर सकता. He has to place the matter either to the division bench or to the chief justice so that even larger bench needs to be constituted in that matter. Now, one division bench decision is binding on another division bench. अगर डिवीजन बेंच है तो प्रीवियस डिवीजन बेंच का डिसीजन है वो सब्सिक्वेंट बेंच पे बाइंडिंग होगा. जजमेंट ऑफ द अर्लियर डिवीजन बेंच ऑफ द हाई कोर्ट इज बाइंडिंग इन सब्सिक्वेंट प्रोसीडिंग्स ऑफ द सेम केस. नाउ द हाई कोर्ट आर द कोर्ट ऑफ कोऑर्डिनेट jurisdiction and therefore the decision of one high court is not binding on the other high. ये तो मैंने आपको बताई. However, in practice they are cited in other high courts as well and they have persuasive value as I already told you. The full bench decision of one high court commands greater respect in other high court. मान लीजिए 5 जज बेंच का, 7 जज बेंच का, 9 जज बेंच का कोई जजमेंट है दिल्ली हाई कोर्ट का, तो इलाहाबाद हाई कोर्ट में उसको ज्यादा रिस्पेक्ट मिलेगी क्योंकि फुल बेंच जजमेंट है. द डिसीजन ऑफ ओल्डर हाई कोर्ट्स, अब ओल्डर हाई कोर्ट्स कौन से थे? पटियाला हाई कोर्ट, लाहौर हाई कोर्ट, नागपुर हाई कोर्ट, फिर आप इलाहाबाद हाई कोर्ट. दीज आर ओल्डर हाई कोर्ट्स, बॉम्बे हाई कोर्ट, एंड डिसीजन ऑफ द ओल्डर हाई कोर्ट कैरी मोर वेट इन द हाई कोर्ट. द डिसीजंस of the federal courts were made binding by section 212 of the Government of India Act 1935, which has been cited earlier, and they continue to be so even after 1950 by the authority of article 225 of the Indian Constitution. तो फेडरल कोर्ट के डिसीजंस हाई कोर्ट्स पे और लोअर कोर्ट्स पे अभी भी बाइंडिंग है. However, they are binding only so long as they have not been overruled by the Supreme Court. वो कब तक बाइंडिंग रहेंगे? जब तक सुप्रीम कोर्ट से उन्हें ओवररूल ना कर दिया गया हो या सुप्रीम कोर्ट की किसी जजमेंट से उनका कंफ्लिक्ट ना होता हो. प्री कॉन्स्टिट्यूशन 1950 डिसीजंस ऑफ द प्रिवी काउंसिल्स आर बाइंडिंग ऑन ऑल द हाई कोर्ट्स अनलेस दे कंफ्लिक्ट विद एनी डिसीजन ऑफ द सुप्रीम कोर्ट. अगर सुप्रीम कोर्ट के किसी डिसीजन से प्रिवी काउंसिल के जजमेंट का कंफ्लिक्ट होता है तो वो बाइंडिंग नहीं है. अदरवाइज प्रिवी काउंसिल के डिसीजंस आज भी हाई कोर्ट्स पे बाइंडिंग है. आर्टिकल 395 ऑफ द इंडियन कॉन्स्टिट्यूशन व्हिच सेव्स द अबॉलिशन ऑफ Privy Council's Jurisdiction Act 1949 makes the decisions of the Privy Councils authoritative in India. The Supreme Court, as I told you, is the highest appellate tribunal or highest judicial tribunal, and therefore the decisions given by the Supreme Court are binding on all the judicial tribunals of the country. This authority to the Supreme Court decisions has been given in unequivocal terms by the Constitution of, so that is judicial precedence. If you have any question, you can ask me.
दोस्तों, इस तरह के वीडियो को बनाने में काफी समय, मेहनत और रिसोर्सेस लगता है. आप अपना वैल्यूएबल फीडबैक जरूर शेयर करें ताकि एबनिशियो टीम को प्रोत्साहन मिले तथा आपके द्वारा दिए गए फीडबैक पर काम करके और इन्फॉर्मेटिव वीडियोस आप तक लाया जा सके. यदि आपको यह वीडियो पसंद आया हो तो प्लीज लाइक द वीडियो, सब्सक्राइब द चैनल एंड शेयर द वीडियो with needy one. Thank you for watching videos. Thanks a lot.